This is going to be a Robertshaw's ramble, but stick with me because there might be some interesting bits of legal trivia that I know you all enjoy. This was prompted by that video where Dan got the cease and desist letter. And being the nerdy sort of person I am, I mentioned that cease and desist was one of those examples of something you get a lot in law, where you get a phrase that has two words that both effectively mean the same thing. So cease and desist, they both mean stop. And I mentioned there's a proper word for this, but I couldn't remember it. But all the nice, clever people in the comments pointed out they are called legal doublets. And I have a few examples here before I go on to ramble further about some interesting implications. So we have things like accord and satisfaction, acknowledge and confess, aid and abet, assault and battery, and we'll come back to that one in a minute. Sorry, that's just the Biffa lorry going. This is meant to be a really quiet place. Covenant and agree, deem and consider, depose and say. There's loads of them, actually. I printed off a big list from Wikipedia. But how did they arise? Well, they arose after the Norman conquest. And what you tend to find is that these are words where they've phrased everything in both Anglo-Saxon and Norman French. It's a bit like the unlawful, illegal thing, and the fact that they actually mean the same thing. They just have different etymologies because of the English language's way of just stealing things from other languages. But the idea was that we've got this thing like ignorance of the law is no defence. You're deemed you have to know what the law is. Everybody's presumed to know it. But that can cause problems in a common law country because there was that case where somebody was convicted of conspiracy to corrupt public morals because he'd produced a ladies' dictionary, which was effectively a booklet that had a list of ladies with a tasteful nude photograph and a list of services they would provide and the fees they charged. And he was prosecuted for conspiracy to corrupt public morals, the conspiracy being he'd agreed with these ladies. And he said, well, hang on, that's not an offence. Nobody's ever been done for this. And it all went off to the Supreme Court, and they said, no, it's a common law offence. We're a common law country. You should have known that was illegal. Now, under the European Convention on Human Rights, everything has to be what we call down by law to be enforceable. In other words, there has to at least be a theoretical possibility of looking at what the law is. Now, if it's a statutory offence, that's simple. You just look at the relevant act. But if it's a common law offence, you have to plough through all the law reports and all the case reports and see how that arose. I mean, like I've mentioned before, murder is a common law offence. There's no statute saying murder is illegal. It's just always been presumed to be. So the idea was that nobody could get away by saying, well, I didn't know what the law was, because it's like, well, we've published it in both languages. We've done it in both Anglo-Saxon and Norman French, so it applies to everybody. But what's quite interesting is, it's like linguistic archaeology, because originally these phrases meant the same thing. The idea was that the words were identical. But time's moved on. So for instance, assault and battery. Assault and batteries were once the same thing, but now they're not. Whilst all batteries are assaults, not all assaults are batteries. Because a battery is where you non-consensually actually touch somebody, whether you touch them or you hit them. That's a battery. Whereas you can commit assault just by putting somebody in apprehension of the immediate use of force. You don't actually have to make contact with them. So that's interesting how that's been frozen in time, but things have evolved. And there are a few examples now where the actual words have slightly different meanings. But this ties in, you may know this thing that like animals and the foods derived from them are different words. So we say, cow and beef, pig and pork, sheep and mutton. And the word for the animal is Anglo-Saxon, but the word for the food is Norman French. And that shows basically who was raising and selling the animals for food and who was actually getting to eat them. But clearly they actually, the purpose here was this applies to everybody equally. It is a common law against both rich and poor alike. this has cropped up a few times in history, and like I say, this is going to be a bit of a ramble. You may have heard of somebody called Draco, and that's where we get the phrase Draconian from, you know, where laws are very severe, Draconian penalties. So Draco, or Draco, depending on, you know, there is an argument that there was actually never such a person, and it's just, you know, it's just a made-up word. But he was supposedly a politician in Athens. And the Athenian, like, plebs at the time, the lower classes, complained that they always got stitched up in legal proceedings because the law wasn't written down anywhere. And only rich people knew what the law was and had access to it. So Draco was tasked with actually writing down the law. Now, he often gets the blame for introducing these draconian laws. But actually, his argument was, I've just written down what the law is. Now, when people saw that the law was very biased towards them, for instance, the penalties depended on the status. So if you were of lower status than somebody and you defrauded them, you would be executed. Whereas if you were higher status, you would just pay damages. And people considered that to be very unfair. And they almost had riots about it. Now, what happened to Draco is shrouded in myth, but we know he was definitely exiled, assuming he exists. And supposedly he was later assassinated in a theatre because everybody threw all their clothes on top of him, and they'll throw their cloaks and hats on top of him until he's suffocated. But although, you know, in myth it's like, oh, it's because he introduced all these terrible penalties, the actual argument is that he just embarrassed the upper classes by showing what the law was and how unfair it was. And that's why he fell out of favour, because they were going, you've just let on to all the plebs now about how we stitched them up, and now you've written it down, they can argue against us in court. So that's why they kicked him out. Ancient legal codes are all quite interesting, actually. We'll have to do something on the Code of Hammurabi at some stage. That's the one where we get an eye for an eye and a tooth for a tooth from, which is, you know, was considered to be quite severe. But at the time, there was no element of proportionality in penalties. It's like, you know, you bumped into a member of the upper classes and they just had you sort of skinned alive. And the argument was, no, the penalty should be commensurate with the offence, so it should reflect the offence. So, you know, if you injure somebody, you should suffer the same injury as them, but no further. There was also a rule that you weren't allowed to do any commentaries on the Codes of Hammurabi. That was introduced in a lot of legal systems. You also see it in some religious systems, like, you know, you're not supposed to write commentaries on the Quran. But of course, everybody does. So technically, under the Code of Hammurabi, me doing these videos, I'd probably get executed. Because the argument was that the law was meant to be simple and easy to follow. We'll just write it down on a big stone tablet that we'll put up in the marketplace, and anybody can see what the law is. And we don't want all these academics confusing things by putting their own interpretation on it. We'll just leave it to the judges to interpret these things. But yeah, thank you for the like pointing that out in the comments. It was really interesting. There are also some legal triplets where you get 3 words that are all used together. But yeah, hopefully, as always, hope you found that vaguely interesting, vaguely useful. I'll say vaguely accurate, because the good thing is a lot of this is so old that you probably can't prove me wrong on it. I'll just go, well, you know, the authorities aren't clear on that point. So there you go. I'm at Jamaica Inn today. I've never actually read the book, but I really like the pub. They do really nice beer in there, although I'm driving today, so I'm just having coffee and crisps. But it's lovely. There's old Bodmin Moor behind me. I was going to go up and do something on some stone circles, but I was in a friend's vehicle, so I thought I won't write it off by driving across a moorland.